Yes.
Mr. Bell, I've had a couple of questions in over the short break from call participants just asking for clarification of some of the evidence you've given earlier. So I'll just pick those up first before going on to my next topic. So
Certainly.
you indicated you were giving evidence about the role that Professor Hayes takes in the assessment of applicants coming onto the scheme. Can I just ask you to clarify whether you know for certain whether Professor Hayes seeks advice from other more specialist colleagues when looking at clinical plausibility, or whether that's just your understanding or
it's my understanding.
Your understanding and expectation.
Yeah.
So are there any formal terms of reference that set out how Professor Hayes, the circumstances in which you would consult with him and and how he would carry out his obligations?
No.
And so, and sorry, just to press the point, it's your understanding, and what's your understanding based upon?
It's based upon the advice I've had from the team on when I asked about his role and how my predecessor had utilised him in the past when I first came into the role, and that's how it was explained to me. He also supports the appeals panel, which is obviously an independent panel, and if necessary, will give his advice to them as well.
So you haven't yourself seen any evidence from Professor Hayes in an email, for example, saying, "Thank you for asking me about this case. I've consulted with X, and this is what he or she has said."
So I have seen emails that he gives back to the team answering questions, but I couldn't, without going back to the emails, I couldn't say specifically whether he had said he has consulted with somebody else or not. And
certainly, I think you provided some of those emails to the inquiry, and I don't recall seeing that either. I was asking you questions about the rationale for the benefit of the doubt policy, i.e. when I think the words you used were when it's in the balance, the policy is to give the applicant the benefit of the doubt. Can I ask you, and I asked you the reasons for that, can I ask you whether this was a part of the consideration in drawing up that policy or indeed applying it, that to do otherwise would be unjust or would lead to unfair decisions?
I couldn't say either. My understanding is it was specifically asked to be input into there by the Scottish Government within the assessment criteria, so that it went beyond the balance of probability, but actually to give the benefit of doubt, which is a slightly lower threshold to achieve. But my understanding is it was put there by Scottish Government colleagues as part when they set up the scheme.
And then just some questions just to clarify the what the bereaved community can receive from SIBS. Is it right to understand that widows, widowers and cohabitees can claim lump sum payments and annual payments? Is that correct?
Yes.
That an estate claim, so which can be bought by a dependent child, can claim a lump sum only.
That's my understanding.
And that a dependent child can make an application for a discretionary payment, including income top-up and one-off grants.
That's my understanding.
Can I now? I'm going to ask you to consider the guidance which we find at WITN 4508007. It's internal guidance for chronic hepatitis C stage 1 widows, widowers and civil partners cause of death assessment guidance. I'll just read out some passages from it and then ask the questions. If a person's husband, wife or civil partner had chronic hepatitis C, so was not entitled to annual payments at the time of their death, and was a Scottish beneficiary, either registered with SIBS or previously registered with the Skipton Fund as a Scottish beneficiary, then they can still apply for an annual payment if they were married to or in a civil partnership with the deceased beneficiary, were still living with them at the time of their death, and have not since remarried. And we've heard evidence this morning from the Scottish Government that last since remarried has now is subject to change.
May I just ask one question? There it is referring to a husband, wife or civil partner. You earlier, a moment ago, Ms. Scott, you asked a question about widows, widowers and cohabitees. Now, cohabitees are not necessarily those in a civil partnership. One would expect those in a civil partnership to be cohabitees, but it doesn't work the other way around. So would they be in or would they be out? A cohabitee who is not in a civil partnership or married?
If the cohabitee, if there's evidence that the cohabitee has a long-term relationship and has been the cohabitee, and it's in a clear long-term relationship, then they would be in.
Thank you.
And is it right that that initially the criteria was civil partner, but quite early on in the scheme that was widened by the Scottish Government to include cohabitee?
That's my understanding.
So this guidance, that may suggest, might it, that this guidance was authored fairly early on in the scheme's history?
Yes.
And I think you tell us in your witness statement that this is guidance that was authored by the Scottish Government.
That's correct.
So just picking up then at the words remarried, last two sentences there. However, there will also need to be sufficient evidence that on the balance of probabilities, hepatitis C directly contributed to the spouse or civil partner's death. And then going down to the next paragraph, this means the applicant will need to complete the same form as the one for widows, widowers or civil partners of beneficiaries with advanced hepatitis C or HIV. And this is the bit I want to ask you about, but they will also need to provide a copy of the spouse or civil partner's certificate of registration of death, contact details for an appropriate doctor who can provide relevant evidence about the causes of the spouse or civil partner's death. Ideally, this should be completed by a hepatitis C clinical specialist who was involved in treating the spouse or civil partner for hepatitis C, but clearly this may not be possible if they died some time ago. In such cases, other hepatologist, infectious disease consultant can be nominated if they have access to the spouse or civil partner's records, or alternatively, the spouse or civil partner's GP may be nominated. So the question I wanted to ask you, Mr. Bell, was is it right to understand this guidance in this way, that if a widow, I'm going to use the word partner to encompass widow, widower, cohabitee, civil partner. If a partner of a primary beneficiary who has deceased with advanced hepatitis C or HIV is applying to SIBS, they don't need to provide evidence that the death, that the infection, directly contributed to their partner's death. But if they are, if the deceased partner was infected with hepatitis C stage 1, then that additional step, that additional evidence must be provided.
So yes, there's a difference between the two. But if somebody was receiving the stage 1, my understanding is if they were receiving stage 1 membership, but that the death certificate highlighted that it was the hepatitis C that was a direct cause to the death, then they could be entitled to the fuller payment of stage 2. So I think there is we have to look at those slightly differently. But my understanding is that the death certificate is required to make sure that we have the cause of death recorded.
So is the rationale behind this, is it because if somebody has advanced hepatitis C or HIV and they die, there is an assumption that the infection directly contributed to the death? So there's no need to have that additional evidence to prove that.
I think we still, I believe the team still look for a copy of the death certificate to confirm, but I think the challenge, and it might come back to thinking back to my earlier comments around the one case that we talked about very early on. That might be one of the reasons that that one widow is noted in a road on her own is potentially because of this. I will double check and write back to you on that, but this could be one of the reasons why that individual is identified on the table separately, because it could be that she's on a slightly different payment because of the stage. So this could be the reason for that. I'll have to, on that particular one, I will write back to you on to confirm.
So because she's on the table as a widow under hepatitis C stage 1, and it may be that that's because in fact she's receiving a hepatitis C stage 2 payment, having submitted the evidence we've just looked at, the death certificate and potentially contact detail. Is that what you're saying?
I think that could be. I'll have to double check and then write to you formally to confirm. But that could lead to one of this. Just as we're discussing this, that's what's coming to my head with that previous point.
But in any event, you think that for a widow of a deceased member who suffers from advanced hepatitis C or HIV would in any event need to provide a death certificate at least in order to register with SIBS?
I think we would ask for that when they inform us. We would help them because obviously we want to. It just speeds the whole process up if we have access to the certificate of death.
And if the partner is unable to satisfy SIBS that the death of their partner was directly contributed to by their infection, does that mean they wouldn't be eligible for payments?
Before we made that decision, the team would try and engage the clinicians involved to ascertain what the conditions and the circumstances were at death before we got to that point.
But ultimately that is the criteria. There has to be a direct contribution from the infections to the death for all widows. Is that correct?
That's my understanding.
All partners, sorry.
That's my understanding.
So did you want to say something? No.
No.
I'm going to ask you some questions about the criteria for self-certification for HCV plus applications. Do you know anything? I'm going to turn to the guidance on that. It's SIBS 40126. Is this the guidance that's on the website?
Yes, it is.
That's the wrong. The wrong guidance. Beg your pardon. I'll have to come back to. I'll have to. Can you take that down, Sherlock? I don't think that's the right guidance. I'll ask you the general question anyway. Do you know how the guidance for this for these applications was drawn up? Do you know who drew it up? Sorry, it is the right. It is the. Sorry, I beg your pardon. It is the right document. I just need to turn on a bit. So, can we go back to SIBS 40126, and let me just show you what I'm talking about, and it's going to help. So this is regular payments for people infected with chronic hepatitis C and their widows, widowers, or partners. But if we turn through to page 7, it says guidance on the 3 categories, and it sets out there the 3 categories of impact hepatitis C has on a member's life. My life is severely affected by hepatitis C, and then if we go over to page 9, we see my life is moderately affected by hepatitis C. And then if we go over to the last page, it says, my life is not noticeably affected on a day-to-day basis by hepatitis C. So the question relates to who drew up this guidance and how that came about.
So this, again, before I took over the directorship of the scheme, but my understanding is that following the clinical review group and the financial review groups, the programme team that was set up by Scottish Government in order to establish SIBS, part of their work was to deliver the various guidance documents, and I believe that this was part of that work that they would then produce, all to be signed off by Scottish Government.
And do you know whether or not the beneficiary or membership community were consulted on what's in that guidance?
Yes, I believe that they were, and it was done through the advisory group, which was set up as part of that programme of work. And some of those members on the advisory group were also members on the clinical and or financial review groups.
And what the scheme provides is that members can self-certify the impact that their infection has had on their life.
Yes.
What would you say are the benefits to that process, that self-certification process, as opposed to one that needs to be evidenced by a medical practitioner or a clinician?
I think first and foremost it highlights that we trust our members to make their self-certification, and that it will speed the whole process up. So if there is a change in their circumstances and they recertify to a higher grade, then it allows us to make the payments, the appropriate payments, more quickly, therefore supporting the member.
And are there any drawbacks to the self-certification process?
From our perspective, working on the assumption that we trust our members, then we don't see why we would introduce additional bureaucracy, which could potentially slow things down. We don't think that would work.
We heard evidence this morning that if somebody wants to move from one category to another, i.e. from, say, moderate impact to severe, that actually they are required to provide some substantiating evidence from a clinician. Is that right? Is that your understanding of how recertifying works?
Yes, that's my understanding. And
given what you've just said about the benefits of self-assessment, has that additional requirement created any difficulties or any problems that you're aware of, either from SIB's perspective or that you're aware of from members' perspective?
Not necessarily from SIB's perspective, but some of the feedback we got in the 2020 survey, membership survey, highlighted that some members found the guidance confusing on self-certification. And one of the actions which we completed only last week was to create a small animation video type explanation to help people through the self-certification process. I believe when I submitted my last statement update to you, I said I would get that to you as soon as it was complete. I believe it completed on Friday, so I'll include that with any follow-up from today that's required.
I'm just going to ask you some questions about the discretionary grant giving, as discretionary grants available. In particular, is this right to understand that there are one-off grants that are given on a discretionary basis and income top-up that are given on a discretionary basis?
That's correct.
And is it also right to understand from your witness statement that it's the Scottish Government that decides whether or not a particular grant, whether it's one-off or income top-up, is means tested?
Yes, the policy for means testing is the remit of the government.
Now, there's some guidance on one-off grants, and we can go to that if it assists. But my question relates to what's not in the guidance rather than what is in the guidance. And so the guidance is in relation to one-off grants that are means tested. And what the guidance doesn't set out is how the scheme assesses whether or not the person should pay for the item that they want themselves, or whether or not they've met the means test, if I can put it that way. How does the guidance is quite detailed on whether or not the member needs whatever it is they're applying for. But how does SIBS then go on to assess whether or not the person should pay for it themselves, or whether, given what SIBS has learnt about their income and expenditure, SIBS should pay for it?
So the first part of the process, my team would speak to the applicant to try and understand what the outcome is required, rather than going straight to a particular solution. So we'd want to try and understand, because there may be different ways of achieving what the member needs, and then we would look at the requirements, and if it was needing to be means tested, then we would look at the sort of overall household income and make a judgment based on the level of household income. There are some things in the guidance, I don't remember exactly off the top of my head there are some things that we don't include in that household income, but others that we do, and we then make an assessment ourselves to decide whether we're paying for the full requirement or a partial payment.
And is that based on effectively the disposable income that's left after you've taken into account the income and the expenditure? And if there's a surplus, then you would make a judgment on whether or not what they're asking for is affordable within that surplus?
Yes.
And would SIBS make a judgment about whether or not something in the expenditure column is frivolous, for example? If there was a high number in there for, I don't know, entertainment, would SIBS adjust their consideration of the affordability of the item and make judgment calls on what's in the expenditure column?
So that's not one that I've come across in my 2 years, but I guess my judgment would be to again assess whether it's going to achieve the outcome. as long as the activity is going to deliver on or contribute towards the delivery of the outcome required, then it should be considered. I guess if I deem I haven't come across a frivolous, the word you used, I haven't come across a frivolous request that I can recall in the last 2 years. It's not.
So the question isn't about the frivolous request. The question is about whether or not SIBS makes a judgment about what people are spending their money on when you're carrying out this assessment of whether or not they can afford it.
We make a judgment on whether the money that they're requesting is being requested for the appropriate things. I think that's the judgment we would be. Does the activity or the service or product or aid, whatever it might be, does it add value to get us to the outcome? That's the judgment that we're making.
I think you may be talking about two separate things. You're talking about the need for the outcome, whatever it may be. I think Ms. Scott is asking about not about that, but about the affordability of it for the individual. And she's suggesting that if you have evidence that somebody would have the resources if they hadn't spent it on something else, which on most people, perhaps, without any explanation, might think is frivolous, then why should SIBS pay for the desired outcome because the person could afford it themselves? That's the point, isn't it?
It is. Yes, thank you, sir.
So, apologies.
Don't apologise.
Then yes, we would be making a decision on that to if it's something that would otherwise be reasonably expected to be paid by a member of the public, or any other member of the public, then we would make a decision on that as not being within the requirement. Is that closer? Does that answer the question, sir?
Well, it was Councill's question. I just wanted to make sure that you weren't at cross purposes on it. So do you want to re-ask it, having had that answer?
Well, I don't know. I don't know that I need to press it any further, sir. I'm not sure it is entirely an answer to my question, but but I'm not sure if I can put it any better than you have, sir.
Well, I didn't ask the question. I just restated it. But yes. It's well, suppose you have this example, Mr. Bell. Suppose you have someone who says, "Well, I have a young family. I have particular needs. The illness has caused me to need to do a lot more washing than I otherwise would. So I need a washing machine. I need washing machine. Need to replace it more often than most people would. So I have this additional expense, and it's quite a large item for the washer dryer, let's say, that I need. Now, that's something which a lot of people have to afford themselves out of their income, but they're not in the same circumstances. They don't have the same need for it. How would you set about approaching that?
So in that specific example, that would probably be awarded. Similar to as people's conditions progress, we might need additional mobility aids. We might need other adaptations to houses. Those would all be acceptable because it relates to the condition. And as you say, if there's increased wear and tear because of the condition is generating that activity, then the decision would be yes, that would meet the threshold, and we would award.
Now, suppose that the outcome then is something which doesn't, on the face of it, relate to the condition, but someone is saying, well, it's because I spent the spare money that I had on buying my washer dryer that I no longer have any money to afford this, which is the sort of thing that any normal, ordinary family not suffering from illness might buy. What would you say about that?
That's, I think, where we get into that benefit of the doubt position, and we would say yes. I think that's why benefit of the doubt this is just my opinion, but I would imagine that is why benefit of the doubt has been applied in the criteria rather than the slightly higher threshold of balanced probability. So, and that's how I personally would use the criteria and the benefit of doubt.
Thank you.
And just taking that example one stage further, if the person was asking for the washer dryer because they needed it for their condition, but you looked at the income and expenditure, and but for the fact that they'd spent £10,000 on, I don't know, something that was considered to be frivolous, I can't think of an example at the moment, they could have afforded it themselves. Would that impact on your decision making?
I'm not. I don't believe. Well, I haven't come across that one. That position. So, hypothetically, potentially, but we don't necessarily go into every detail of of people's expenses. You know, we look at the general household income and try to make a balanced judgment. But we do use the benefit of doubt approach where at all possible, because we're trying to get the best outcome. Again, from my personal perspective, I would be wanting to make sure that whatever we're giving is contributing towards something, an activity, a service, or an item that will help the overall, outcome, which could just be quality of life. Improving that quality of life for the member.
And you tell us in your witness statement that since the self-assessment for the 8 hepatitis C payments have come in, you've only had 5 applications for discretionary one-off payments. Is that right?
I believe that's correct, yes.
And do you have can you help us on why do you think that is?
In terms of
why there've only been 5 applications since then?
In terms of self-assessment, if an individual can self-assess at any time, I think we're coming up to the 3-year point where we would expect a number of self-assessments to be reviewed after the 3 years, and so I think there might be something to do with the timeline, or just the fact that people's conditions have not deteriorated over the first couple of years of the scheme.
I'm going to ask you a couple of questions about the discretionary income top-up grants that are available. Is this right, that it's available for 2 categories of people? So first of all, those who need to take time off work for treatment for hepatitis C, typically, and secondly, for those on low incomes, and it's means tested so that their income is topped up to 70% of net median UK household income.
That's correct.
I'm just going to take you to 2 documents and just see if you can help us with the numbers claiming. The first is the Freedom of Information Request, SIBS 40123. Just find my copy of that. So if we go to, we can see on the first page a little bit further down, the date responded was the 5th of September 2019. Information requested details of the numbers of beneficiaries at SIBS who are in receipt of specific one-off grants or other available funding such as income top-up support. Application for living cost supplements or support and assistance grants used towards the cost of social care and the care of infected victims, such as additional funding to support respite care, additional care support. And if we go over the page to page 2, we can see the response at the top half of the page. Response question 1, category number. It's got category income top-up support 50. living cost supplement 213 and one-off grant 10. Just pausing there. The living cost supplement, that is a non-means tested supplement provided, is it, to anyone that has an annual payment? Is that correct?
Yes, I think the living cost supplement also includes an element of what the other schemes would have. Winter fuel allowance, for example, the living cost supplement, I believe, incorporates some of that.
And so we can see there that on the 5th of September 2019 that there were 50 people claiming the income top-up support. And the next document I want to take you to is the minutes of advisory group in April 2021, and that is WITN 4728036. You see there, minutes of advisory group, 8th of April 2021. And if we go to the last page of, the third page of that document, and there's the last bullet point at the top of the page there, annual payment income top-up. SB, I think that's Samantha Baker, advised that the annual payment going forward, it was hoped this would remove the need for income top-up. Currently, only one member of the scheme was receiving this. Do you know, can you tell us why the figures have reduced so drastically between September 2019 and April 2021?
I believe it's because the payments that the members are receiving takes them above the threshold for requiring an additional top-up.
And is your, in terms of the future of the income top-up, is it your understanding that that's going to be reviewed?
My understanding is it will be reviewed on the announcement from 25th March. If that's enacted, which we believe it will be by government, then the increased levels through parity would, under the current criteria, remove all our members from the need for the income top-up.
And just picking up another point, just on that document, if we go up to the previous bullet point, means tested discretionary payment for children already in English schemes. DFS asked the group if a formal review was required of the discretionary scheme as the main payment was increased. Advanced he'd been made aware of a payment for children in the English scheme up to age 18 and anyone under 21 in full-time education, and asked if some of the funding for the stage 1 no noticeable impact group could be used for this. SB confirmed that until recently she was not aware of this. She added that she would look to discuss this with DHSC to consider whether it would be permissible and new ministers when in post. And DFS and TL added they would look into potentially how many members could be affected. Is there anything else to report in relation to that? Is that still under consideration?
That's still under consideration. I think you'll note from the date of the meeting was shortly before the pre-election further period came in. So we've not been able to have those discussions with government until last week when the election was completed.
I've just got two brief topics to ask you about. The first is in relation to the other services that SIBS provide, so not financial services but other services. Excuse me while I find the document. It might be helpful to look at the action plan arising from the 2020 consumer survey, member survey, which is at WITN 4728013. So we can see, we spoke about this briefly earlier, that's the front page of it. If we go to the, we go please to page 16. In fact, we better start at page 15. We asked scheme members, are there any services that SIBS does not currently provide which you would like SIBS to make available in the future? And at the bottom it says members said 71% are happy with the current level of support from SIBS and did not think there were services which should be available. However, 12% would like SIBS to provide additional services. And then over the page there's an action plan arising from that. And the second bullet point down there, mortgage support. For members applying for a mortgage, we provide a letter to lenders on request to give them reassurance that members receive regular payments. We'll highlight this service in our newsletter. Is that a service that you've offered to members as far as you're aware from the beginning?
As far as I'm aware, that's been from the very start, yes.
There's a reference then to prescription prepayment certificates for English residents. There doesn't seem to be an action in relation to the Scottish residents there.
All prescriptions are free in Scotland.
Yeah, and then support groups. You list support groups on your website. Help with insurance costs. And we had some evidence about this morning. The action point there is we will explore this issue with insurance suppliers to ensure that members are being treated fairly. And we had some evidence about that this morning. There's an item on funeral costs and then on benefits advisor, exploring whether there are suitable benefits advisors available. And we heard evidence from Mr. Neil Bateman earlier this year that he was contacted by SIBS in August 2021. Was that as a result of this survey that he was contacted and he has begun working with some of the members there on benefits advice, giving benefits advice?
It could be. I don't, off the top of my head, I don't recall the name, but that's possible. That the team have been trying to engage as many people as possible to help with these, and also to develop the action plan going forward.
Does SIBS offer or signpost or provide grants for members to receive debt advice?
I'm not sure about debt advice. We certainly signpost to people like Citizens Advice and counselling and etc. We do as well. We've also helped with people who have had challenge with DWP because of their SIBS payments, which should not be considered by DWP. So we've written to DWP on members' behalf, but I don't recall specifically about debt advisors, or certainly I don't think so.
So that brings me on. Your last answer brings me on to my last question, which is in relation to the information the advice rather that SIBS has been given by the DWP about the requirement for members to declare their SIBS payments to the DWP. It is right to understand that the DWP have told SIBS that the members must declare their SIBS payments to the DWP to avoid being called in for interview for fraud when data matching exercises are carried out. Is that correct?
Yes, that's correct.
And that you have informed your members of their obligations to do that?
Yes, we have. And indeed we have. As I said, we've had members contact us where, for whatever reason, DWP have taken their SIBS payment into account when dealing with their benefits, and we've had to write to DWP to remind them of the arrangement that SIBS payments should not be considered when DWP are doing their assessments.
So if members are having difficulties with the DWP, one of the things they could do is notify SIBS, and SIBS may be able to help them out.
Yes.
So those are the questions that I had for Mr. Bell. I've had some questions in from call participants, but they will need an opportunity to provide me with more questions.
Well,
to ask.
How long do you think you might need?
15, probably, 20 minutes I should probably.
Right, well, if we say quarter to 5, let me explain, Mr. Bell. The core participants to the inquiry have a right through their legal representatives to put further questions through counsel. It's obviously sensible to field those questions now and ask you to come back into the hot seat at quarter to 5.
Yep.
Thank you very much.
Sure.
Quarter to 5.
Sure. Thank you.